forget to like, comment, share, and subscribe. Once you sail out of Houston and leave the national boundaries of the United States, even if you're a U.S. citizen employed by a U.S.-based company on a ship registered in the U.S., some laws designed for your protection no longer apply. Fortunately, other laws move into play that restore some of those protections, but in a different manner. One such law is the Marine Act. It is an expansive law that includes regulations governing maritime commerce in U.S. waters between U.S. ports. Section 27 of the Marine Act, known as the Jones Act, requires that commerce between U.S. ports be transported only by American-built vessels. The Marine Act and the Jones Act are often used synonymously, but in actually, the Jones Act is a part of the Marine Act. The Jones Act also includes provisions that have seafaring workers' rights at their core. These provisions include, among many others, the owner of the vessel must use reasonably care to maintain it for safety and seaworthiness. The owner can be found liable if it is found negligent and the negligence led to an injury. Qualifying sailors officially classified as a seaman who have suffered injuries or illness while at sea can recover appropriate compensation from their employers by lawsuit if necessary. The notion of a vessel's seaworthiness is extremely important, as it can move a case from one where the best outcome would be the recovery of basic expenses, called maintenance and cure, to one where all the victim's losses are recoverable. The major provisions of the Jones Act apply to a special class of worker called a seaman. It is a legal recognition and very important to the process when injury claims are filed. But there is no binding definition of a seaman anywhere in the Jones Act or the Marine Act. There is precedent, however, and maritime attorneys for both sides have to sort through past cases to determine if the plaintiff qualifies as a seaman. Simply being employed by one of Houston's many shipping companies and spending time out at sea working that the job is not enough to qualify as a seaman. In lieu of a legal definition, most maritime lawyers and judges typically agree on the following definition, but the definition has undergone a metamorphosis of terminology over the years, and it is still subject to revisions. That is nice and tidy and refinement of more cumbersome definitions that preceded it, but the Jones Act sets progress back a bit, insisting that to qualify as a seaman, the worker must spend at least 30% of his or her time on board. Up at sea, it's a point upon which the opposing sides in an admiralty case can argue for hours. Without an overarching definition to go by, however, it often becomes a stumbling block to the process. Workers who don't satisfy the terms for the definition of a seaman can still recover damage from the Longshore and Harbors Worker Compensation Act. This federal law allows the injured party to recover losses for medical expenses, passage, rehab, in ATC. Due to an injury as well as survivor benefits if the injury causes the worker's death, This covers dock workers, shipbuilders, and harbor construction workers who were injured in the wharf area of the harbor. The provisions of the LWHCA differ from standard workmen's comp laws and generally provided for slightly better compensation. Without the safety net of workmen's comp, maritime employees often have to rely on the provisions of the Jones Act for compensation. In a few ways, maritime workers actually have a better system at their disposal, which is why contacting a maritime injury lawyer is of utmost importance when an injury has occurred. With the provisions of the Jones Act to rely upon, maritime workers can file negligence lawsuits that go beyond the standard maintenance and cure for certain types of injuries. They can receive a more substantial settlement when they file a negligence suit and only have to prove that the employer's negligence merely contributed to an injury in some ways. In other words, the negligence doesn't have to be the entire reason for the injury. It can actually play a very small role to be relevant. Employers can contend that maritime workers must acknowledge the substantial inherent risk of working aboard a seagoing vessel, but that doesn't absolve the employer or ship owner of liability when something goes wrong. Employers are expected to build and maintain the ship to code, make repairs as needed, and provide a safe work environment. Reasonable care must be exercised, and they must foresee potential for mishaps and for mishaps and take steps to eliminate them. Negligence is not limited to the way the ship is maintained. Sometimes decisions that put workers at unreasonable risk must be held to accountability, requiring workers to perform tasks in unsafe sea conditions, forego safety procedures, perform tasks for which they have not been trained, or to stray from accepted practice regarding seagoing cargo are just a few examples of conduct that can be considered negligent. Maybe that's all from me. Thank you for watching. Don't forget to like, comment, share, and subscribe.